What are we dealing with? Canadian-born, Obama-appointed U.S. federal judge Sarah Ellis has gone full estrogenically hysterical and ordered U.S. Border Chief Greg Bovino to appear personally before her and explain why he purportedly violated her court order forbidding Bovino or any ICE or Border Patrol personnel to deploy tear gas against protesters. The problem for Judge Ellis, besides being Canadian-born, first, this unelected black-robed tyrannical inferior district trial court judge lacks the authority to micromanage the Article 2 executive branch Border Patrol. If she wanted to be commander-in-chief, if she wanted to be in charge of immigration, she should have run for president. And this is the chaos, folks. All of this is another reason why these decisions for the deployment of U.S. military forces cannot be in the hands of unelected judges. This is chaos. This is why our founders created a single commander-in-chief in the executive branch, not a congressional committee, not a panel of black-robed judges to decide how U.S. military forces would be deployed, and why Congress delegated their authority under the militia clause of the U.S. Constitution to the president. Because you can't have this kind of chaos. Back and forth every couple of days. Are we deployed or are we not deployed? Does the president have troops to use or not have troops to use? The judges will decide. 833 unelected black-robed tyrannical inferior district trial court judges apparently have a veto over whatever the commander-in-chief wants to do with America's military forces. It is utter madness. Judge Sarah Ellis was unhappy with our Border Patrol dealing with protesters, and particularly she didn't like how they were using tear gas. A bunch of journalists sued and said, hey, we're just journalists. First Amendment, we're getting tear gassed. Of course, they're embedded amongst the violent protesters for whom the tear gas is being used for self-defense purposes. But the judge, Sarah Ellis, said, I'm going to issue a TRO to constrain the ability of Border Patrol to use tear gas. And she issued this, which we're going to look at a little more closely in a moment. Modified temporary restraining order. The defendants, and that, of course, is Kristi Noem, Department of Homeland Security, and all their officers and agents and everyone else are temporarily enjoined in this judicial district from dispersing, arresting, threatening to arrest, threatening to use physical force against any person they know to be a journalist, unless they have reason to believe the person has committed a crime. Where's self-defense fit into all this? Issuing a crowd dispersal order requiring any person to leave a public space they have a right to be, unless there are exigent circumstances, prohibiting the use of riot control weapons, including OC spray, CS gas, tear gas, CN gas, another form of tear gas, other chemical irritants, and a whole bunch of stuff. So she'd issued this order. And then we come across this video of Border Patrol Chief at Large Bovino. Here we go. Border Patrol Commander Gregory Bovino caught on camera throwing tear gas canisters into a crowd. Attorneys in a federal lawsuit say he violated the court order we just looked at, prohibiting agents of DHS from using tear gas and other riot control weapons on protesters and journalists.
Also breaking, that same incident in Little Village, also sparking a notice of alleged violations against Border Patrol Chief Gregory Bovino. There's a court filing by the Chicago Headline Club, and it accuses Bovino of throwing tear gas into a crowd without justification, violating the temporary restraining order in place.
Of course, it's the media and it's Canadian-born judges. By the way, why do we have so many foreign-born federal judges in America? America is a nation of over 300 million people. We can't come up with homegrown judges? American-born judges? This Sarah Ellis did not become a naturalized citizen until she was almost an adult, 15 years old. She's not culturally an American. She's culturally Canadian. And by the way, she, like Ali Amir, Judge Ali Amir, appointed by Biden after Trump was reelected, she was not even culturally Canadian. Her family came to Canada as third world migrants. And somehow we end up with her as a lifetime appointed federal judge issuing these orders to our elected Article 2 executive branch. And of course, they're lying. They're lying. Tricia McLaughlin, spokesman for the government, says, of course, CNN refuses to mention that rioters hit Chief Bovino in the head with a rock, which could have been deadly. Of course, a rock to the head is deadly force.
Right here in this video, you can see Border Patrol Chief Gregory Bovino appearing to throw a tear gas canister toward anti-ICE protesters on Thursday. So right here, we're freezing the video so you can see it more clearly. As the protesters run away, the camera shows a cloud of smoke in that area. The Department of Homeland Security says protesters threw rocks, prompting Bovino to throw that canister of tear
how about
gas.
that?
And in a statement, they say, quote, the use of chemical munitions was conducted in full accordance with CBP policy and was necessary to ensure the safety of both law enforcement and the public. Wolf.
Two dynamics at play here, of course. One is, as we look at the judge's temporary restraining order, we'll find that she had to make a lot of carve-outs of her order for things like exigent circumstances, for things like necessary self-defense. Why? Because a federal judge lacks the authority to micromanage executive branch law enforcement and compel them to incur life-threatening injury at her whim because she's having a bad day. She doesn't have the authority to endanger federal law enforcement officers in the conduct of their official duties. She's not in charge of them. Congress did not confirm her as Secretary of Department of Homeland Security. The American people did not elect her to be the Article 2 Chief Executive Officer of our nation, our one president to whom all executive authority is delegated by the Constitution in our constitutional order as created by the founders. No one elected Judge Canadian-born, third world immigrant Sarah Ellis to be the commander-in-chief of our U.S. military forces and officers. She simply lacks that authority. So she had to make all kinds of carve-outs for exigent circumstances, for self-defense. And of course, that's exactly where all this fits now. Temporary restraining order, and this is Chicago Headline Club. So this is a bunch of purported journalists. They're complaining they're getting tear gassed when they're embedding themselves amongst violent rioters and insurrectionists, threatening our federal officers with force for simply doing their duty, carrying out immigration enforcement. The journalists don't like that when they're in these crowds, they also have to inhale the tear gas. They're also occasionally subject to defensive force because they're part of a mob. So they went to Judge Canadian-born, third world immigrant Sarah Ellis, lifetime appointment to the federal bench appointed by Barack Obama. Thanks, Barry. Another win for Barry Obama, on top of Obamacare, cars for clunkers, all the rest of it. Plaintiffs here, the journalists, filed an emergency motion for a TRO. Hearings were held. The court finds the plaintiffs have met their burden for the TRO. Let's see. The court finds it necessary to modify a previous TRO, so this is the modified temporary restraining order against the Article 2 executive branch. Ordered the defendants, Homeland Security, and their officers, agents are temporarily enjoined in this district from dispersing, arresting, threatening to arrest, threatening or using physical force against any person whom they know or reasonably should know is a journalist, capital J for journalist. Why is that? Is journalist a proper noun? Of course, it's one of the left's foot soldiers, right? So that they're capitalizing it like they would private or corporal or sergeant. How should they reasonably know someone's a journalist? Because they put a Velcro journalist patch on their jacket? Is that enough? That's not hard to fake, is it? Unless the defendants have probable cause to believe the individual has committed a crime. What if they're about to commit a crime? What if they're pointing a gun at the head of a DHS agent, about to shoot him in the face? Defendants may order a journalist to change location to avoid disrupting law enforcement as long as the journalist has an objectively reasonable time. Who knows what that is? What is that? And an objectively reasonable opportunity to report and observe. DHS officers are supposed to work all this out while they're being pelted with explosive devices from insurrectionists. Issuing a crowd dispersal order requiring any place to leave a public place that they lawfully have a right to be They're prohibited from doing this unless dispersal is justified by exigent circumstances as defined by Homeland Security Use of Force Policy Sections 3F and 12E. I wonder what Sections 3F and 12E of the Department of Homeland Security Use of Force Policy have to say. Well, fortunately for all of you, I have these documents. Exigent circumstances. In an exigent situation for self-defense or the defense of another, DHS law enforcement officers are authorized to use any available object or technique in a manner that is objectively reasonable in light of the circumstances. That would certainly include less lethal force, like pepper spray, CS spray, CN spray, all less lethal force. So that's allowed, even under the judge's order. And what about 12E? Let's go find that. Exigent circumstances. A situation that demands unusual or immediate action that may allow law enforcement officers to circumvent usual procedures in order to preserve life or prevent catastrophic outcomes. Is getting hit in the head with thrown rocks and or explosive devices something that could lead to a catastrophic outcome or a threat to life? Of course it is. And the judge has to bake this into her order because she knows it would be completely lawless without this. No one has the authority to order someone else to die on their whim. You cannot defend yourself against unlawful attack. A judge can't order me to do that. Use of riot control weapons. So they are enjoined. They're enjoined from using riot control weapons, including kinetic impact projectiles, compressed air launchers, OC, which is pepper spray, CS or CN gas, other chemical irritants, 40 millimeter munitions launchers, less lethal shot. All of these are less lethal, controlled noise, and light distraction devices. She's ordering DHS law enforcement that they're prohibited from using noise and light. They're prohibited from using noise and light. Are the protesters using noise and light? Electronic control weapons, that would be tasers, on members of the press or protesters or religious practitioners who are not posing an immediate threat to the safety of law enforcement. Well, if you're part of a violent mob, everyone in the mob is responsible for the conduct of the mob. They're acting as a coherent group. It's insane to expect that, especially with the gas, less lethal tools here, that they can be personally directed at the individual who threw the rock or fired the explosive device. These are area weapons because the mob, the riot, is occurring in an area. If you don't want to be exposed to OC gas, don't be embedded in violent protesters attacking law enforcement officers compelled to use those to defend themselves. They're prohibited from using riot control weapons, including all of those, at identified targets if it's reasonably foreseeable that doing so can result in injury to the press. So as long as there's one so-called journalist in the crowd of violent protesters, DHS cannot defend themselves. So, of course, what do the violent protesters do? They'll just pick one of their own, put a press patch on them, dress them up as a priest, and now they are immune, legally immune from the use of defensive force by the DHS officers they're attacking, because those are embedded within the violent crowd. They're prohibited from firing CS or CN gas canisters, controlled noise and light distraction, less lethal specialty impact, and chemical munitions so as to strike any person unless the person poses an immediate threat or causes serious bodily injury or death. Oh, if they've maimed or killed somebody, then it's okay. Firing compressed air launchers so as to strike the head, neck, groin, spine, or female breast, or striking any person with a vehicle unless the person poses an immediate threat of serious bodily injury or death. All of these munitions, striking someone with a vehicle is, of course, in many circumstances, a use of deadly force, but all these others are explicitly less lethal force intended, designed, and trained to be used against less lethal attacks, ones that do not qualify as serious bodily injury. By the way, what's the foreseeable An unavoidable consequence of telling DHS law enforcement that if someone is attacking you and you're prohibited from using less lethal force, what's left? They can let themselves be maimed or killed, or they can escalate to deadly defensive force. They cannot use force such as pulling or shoving a person to the ground, tackling or body slamming an individual who poses no immediate threat of physical harm to others, unless necessary and proportionate to effectuate an apprehension or arrest. This is already the law. But when the judge puts this in an order, now it's the judge deciding whether something was reasonable or necessary, as opposed to the officer's superiors. A judge who's obviously hostile to the safety and duties of these officers. Prohibited from using any riot control weapon without giving at least 2 separate warnings, when feasible, at a sound level where the target individual can reasonably hear it. Who would know this? How would you know in the chaos of a riot whether an order you're issuing can be heard within the crowd? Law enforcement officers determine feasibility by considering whether the resulting delay of issuing the warning and allowing reasonable time and opportunity for them to violently comply is likely to create an immediate threat of causing physical harm to the officers or others. So they're not allowed to order disbursement unless the disbursement is a necessary self-defense. What about obstructing? What about obstructing the operations of ICE, getting vehicles in and out of their facility? That's a felony. That's an 8-year felony. And the officers are not allowed to enforce that law. Such warnings shall explain that the defendants may employ riot control weapons, give the targets reasonable time to avoid the use of force, and provide a reasonable opportunity to comply. These officers are prohibited from seizing or arresting any non-violent protester who's not resisting a lawful crowd dispersal order, unless there's a specific probable cause to believe they've committed a crime for which custodial arrest is warranted and for which the law enforcement officer has lawful authority. Well, this is already the law. You can't arrest people for no reason. You need a legal reason. But of course, now it's the judge who's going to be hauling these officers into her court anytime a so-called journalist complains that this order has been violated. To facilitate the defendant's identification of journalists protected under the order, the following are examples of indicia of being a journalist. Visual identification as a member of the press, such as by carrying a professional press badge, press pass, badge, or credentials. Distinctive clothing or patches. So anyone wearing a journalist patch now is protected by this order. Carrying professional gear, such as professional photographic or videography equipment. Do you think DHS is trained in identifying the difference between professional and amateur photographic and videographic equipment? So what is this order supposed to do? Are we supposed to believe that these controlled gases, pepper gas, tear gas, can be used in a manner that it only affects the violent actors and not the fake journalists and pseudo hoax religious practitioners? Anyone puts on a priest collar from a Halloween costume store? Unbelievable. All right, that's her order. Then Bovino got hit in the head with a rock or an explosive device. They deployed tear gas, non-deadly defensive force against, by the way, a deadly force attack. Gunfire would have been warranted against this attack. And so the journalists run back to the court, of course, and complain about it. Plaintiffs are filing this notice without completing a conferral with the government. In other words, they didn't first go to the government and say, hey, is there a reason you threw that tear gas? Are you in violation of the court order? Or was there an exigent circumstance? They didn't bother having that conversation. That's a phone call. By the way, their lawyers can call the DHS lawyers and say, hey, listen, we got this video of Greg Bovino throwing a tear gas canister into the crowd. Unless there was an exigent circumstance, that's a violation of the court order. Can you tell us what happened? Nope. They're filing this complaint with Canadian-born cultural third worlder federal judge Sarah Ellis without even phoning the government to see what was going on because of their significant concerns that the defendants are simply ignoring the court's TRO. Did you ask them if they were? No. This morning, defendant Bovino was personally present in Chicago, apparently throwing tear gas into a crowd without justification. Apparently without justification. Did you ask them? Then they had, here's a still frame of the video. Well, of course he's tossing it. That's not the question. The question is, did he have justification? In the video, defendant Bovino appears to throw either one or two tear gas canisters over the heads of federal agents and in the direction of a crowd, including an individual filming the encounter. So he's embedded in the crowd. This action violates multiple paragraphs of this court's TRO, they say. Plaintiffs are currently working on providing the court with declarations, so sworn statements from the protesters in the crowd regarding this incident, and they will confer with the government after filing the complaint. But they wanted to bring it to the court's attention as soon as possible, given the flagrancy of the apparent violation. What a bunch of P words. The plaintiffs asked the court to conduct an inquiry into this incident and order relief that the court deems proper. And of course, the court was happy to do that. This court sets a status hearing for 10/28/2025 at 10 a.m. The court orders defendants to produce defendant Gregory Bovino in person for this hearing. Just contemptible. I don't know if this TRO has been appealed or not. I didn't have a chance to check before the show, but obviously it should be. It's lawless on its face, and it's lawless in its application as applied to these circumstances. Scott Wiener says, I wrote California's law banning ICE agents from wearing masks, SB 627, because no one should have to live in fear of secret police tactics. If someone you know gets detained by ICE, call this number. Well, unfortunately for Scott Wiener, as acting U.S. Attorney Bill Iselli says here, state law does not apply to federal agents. If someone you know impedes a federal agent, call the FBI. And of course, what he means is state law that conflicts with that agent's execution of his lawful duties does not apply. Obviously, if a federal agent just commits a shoplifting or a DWI or domestic abuse, of course he's subject to state law. Those are not functions within his official responsibilities as a law enforcement officer. But anything a federal law enforcement officer that is part of his official duties is exempt from state law. Obviously, FBI agents can carry guns concealed everywhere in the U.S. They don't need a concealed carry permit from California or New Jersey or New York or Maryland. They're allowed to carry guns concealed independent of state prohibitions. They're allowed to break the speed limit in the execution of their duties. And yes, they are allowed to change their license plates or even fake license plates in the execution of their duties. Scott Wiener, of course, he can't get it because he's an idiot. He says state law most certainly does apply to federal agents. You're committing malpractice by repeatedly advising federal agents to ignore state law. They ignore state law at their peril. Who's going to arrest them for wearing a mask against your rule? Wiener. By the way, this is Wiener, openly gay, goes to all the gay parades. He literally wrote and passed a law that decriminalized intentionally giving AIDS to another human being. He tried to pass a law decriminalizing, how can I put it for YouTube? Child images, interaction between grown men and children. That one didn't get through yet in California. That's this guy. And what if the local cops attempt to do this? Well, guess what, my friend? That is impeding federal law enforcement officers. And if you touch them while you're doing that, it's an 8-year federal felony. Who's going to enforce these rules? This guy? Federal law is supreme over state law. If there's a conflict, now the federal government doesn't have laws on everything. It doesn't have, to my knowledge, there's no federal DWI law, for example. Where there's no conflict, obviously the state law is in place. But where there's a conflict between state law and federal law, the federal law is supreme. How do we know? Because the Constitution tells us. Article 6, Clause 2, Supremacy Clause. This Constitution and the laws of the United States, meaning the federal government, shall be the supreme law of the land. The law of any state to the contrary notwithstanding. That would include where there's any conflict between federal and state law and where the federal government is engaged in its own official conduct.